Hey, good morning. We are here on our jury review. First part of the docket, we've got a number of pleas as well as the main business. Well, both of them. We'll do the pleas first because they'll be quicker, and then we will do our jury reviews. So we'll begin, we'll just go down through the pleas based on the docket. So we'll start with Roy Cato. Mr. Nope's here. We'll just skip over it. We'll come back. Sure. Okay, Mr. Nope's on that one. Hartzog, Mr. Shaw, Tim here.
I'll walk out there and
Eric McKinney, John Wilkins.
He was here too. You scared me.
There's something,
Would it be possible to address Christopher Neese? It was an add-on, and defense counsel came. I know he traveled a good ways to get here this morning. It's just the state's motion for modification.
Hold on. I don't know anything about it, so I'm more than willing to do it, but you got to slow down. Who's the opposing counsel?
Christopher Madden.
Mr. Madden, come on.
And the case is Christopher Neese. It's 22 CF 1190.
Good morning, Your Honor.
Again, the name?
Christopher Neese is the defendant's name.
Neese, N-E-E-S-E?
Yes, sir.
Okay. Okay. Again, I don't know anything about it, so what are we?
It was an add-on, Judge. The state filed a motion for modification of sentence. This defendant entered into a plea agreement on Monday. Was it Monday? Monday. And the original agreement was to have no contact with the victims, Angela Griffith and Kelly Robinson. Then probation spoke up and mentioned that there was a child involved, so we needed to allow some type of modification to allow communication through third party with the child. But the way the court minutes reflected, and I believe the plea form was amended, was to reflect no hostile contact with the victims, Kelly Robinson and Angela Griffith. The child is not either of those. So what the state is asking for is just a simple modification to say no contact with Kelly Robinson or Angela Griffith except for communication regarding the child.
So there's two things so we can clarify. One is contact, one is communication. Those are the two different things, fundamentally different. What are you asking the court to do? Is it no contact and allow communication, which is what we would normally do if there are continuing issues? Or are you saying contact?
Judge, I think the
Which is
wordage.
no restriction.
I think the wordage should be no contact with Kelly Robinson and Angela Griffith except for contact regarding the minor child. And I think that covers any contact. That's okay. So if they have to drop off the child?
No, I'm not going, that is not clear. Contact regarding child is not clear. You talking about verbal communications? Are you talking about physical, they can exchange?
Yes, sir.
You're getting into you've got to define it clearly so you don't put the defendant at risk of being violated, because it's a very serious violation. You violate this, you're going to be back in jail, and so you have to make it clear to them. I don't know what that means, no contact except regarding the child. So if he walks up to her in a public square and mentions the child, he can have contact?
Maybe we could invite probation, the best way to word it.
The way I would suggest it is just say no contact with the victim, but he can communicate with the victim as it relates to the child. Communicate, not contact. There's a difference between contact. As long as you can call on the phone, you can talk to him relating to that. You can text him. We can limit it to texting or emailing. That's the other thing. Then there's always, if there's a real issue, you do it through texting and community. You do it all the time in domestic violence injunctions. Every court date we do it. So it's very common. So you can do it through texting. If you think there's a risk, you do it through texting, email communication.
Or telephonic.
The next level up is, yeah, you can call on the phone and talk to her about the child, but nothing else, no contact. And then the highest level is, yeah, you just have contact. But you can't have contact as it relates to the child. I understand what you're getting at, because if you have no contact, that means you must have a third-party facility to exchange. So, again, those are all levels. I don't know the particulars. I just did it based on the plea agreement. So help me out. I'm open to doing whatever, I want to make sure the victim is safe, but I understand the reality of the child, we're not trying to limit or eliminate contact with the child.
Defense.
State, what's the state's position?
Judge, I'm fine with wording it as no contact with Kelly Robinson and Angela Griffith, except for text, email, or telephonic communication regarding their minor child.
We didn't have an objection to the original. We don't have an objection to this. Your Honor.
Very good, that's perfect.
Thank you, Judge.
We'll amend the order to reflect that.
Okay, do I need to submit any type of written order with the specifications? I'll do that and I'll
You do,
send it.
because again, it's important, we want to define this clearly for you. We're not trying to do a gotcha where you're going to get into further trouble. We want to clearly define, here's what your parameters are, here's the contact. We want you to have contact with your child, but because of the issue here with this case, no contact with the mom. So the middle ground is you can communicate via text, email, or telephone as it relates to the child.
I think we good to submit it.
I'll submit the order,
Proposed orders
Judge.
for me
Yeah,
to.
I will.
Very good.
That's all I have, Jason. Maybe excuse. Thank you.
You ready to go, Mr. Nopes? Okay, well, you want to start with Cato?
Yes, sir. Nitsme or whatever his name, he said that his mother had a trust.
Do you have a jail list? All right. Yeah, we'll do all the non-jury review. I've got them on my list, you don't have yours. Yeah, I can show you, well, okay. We'll just roll with it. Go ahead, Mr. Nopes.
Judge, I've got Mr. Cato here. He's got 2019 CF 2856, 2020 CF 3222, and 2021 CF 1233. Judge, we've agreed to put it on the December 1st docket. We're very, very close to resolving it.
No objection.
It will continue to December 1st in the morning. Nitsky is the next one. You ready for Nitsky, Mr. Nopes?
Judge, yep, I'm ready.
Yeah.
We're in the same boat on it, Judge.
Okay, well, hold on, yeah, go ahead. Did we identify the case numbers in the Cato?
We did
We
on
identify the case numbers in Cato for the court record?
We did, Judge.
So go ahead and announce Nitsky and the case numbers.
I'll come talk to you, okay? Judge Maurice, pronounce your last name. Nixky, 22 CF 2244. Judge, we're going to put it on for December 1st.
Okay, in the morning.
Hold on a second. Judge, let me talk to him just a minute.
Okay.
I'll come talk to you. I need to talk to him.
Did we find Mr. Shaw? Morning.
Morning, Your Honor. Morning, Judge. Tim Shaw and Jack Wilkins for Derek Jonathan McKinney. This is 18 CF 1006. Judge, we have been in discussions with the State Attorney's Office, and at this time, Mr. McKinney would withdraw his previously entered plea of not guilty, tender a plea of nolo contendere to the lesser included offense under 782.07, manslaughter with a firearm. We're asking the court to order a PSI and set it off for sentencing. I would assume probably about 2 months. 60 days. No, the holidays coming up and all.
Give us into
90 days.
February, that would be better, Judge, but, I mean.
No objection.
That's fine, Judge.
Okay. I don't have a February date. February 14th?
Valentine's
Let's-
Day, Judge?
I'm sorry?
Valentine's Day?
Well, unfortunately, that's not a court holiday, so, yeah, we do it on, we're not trying to make a statement on that, but we do a, you want to do it then, or you want to do it the 21st? It's okay with me.
Let's put it on the 14th. Put it on the 14th, start.
February 14th? Okay.
May I approach, Judge?
You may. That'll be on the afternoon, 2 o'clock.
And that is the agreement, Your Honor.
Okay,
The state will provide a score sheet at sentencing.
very good. Mr. McKinney, would you please raise? That's all right. Are you all finished? No, take your time, but if you need to say something. Hold on a second. Mr. McKinney, do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay. So you heard your attorney state the terms of the plea agreement. There's a lesser included charge, manslaughter with a firearm. And I see that the plea and sentencing agreement has your name on it and reflects the same
Yes, Your Honor.
plea. Now, what are the 1020 life inapplicable, no minimum mandatory?
That's correct, Judge.
That's part of,
Manslaughter with a firearm, the lesser included that's being pled to, it's not under the 1020 life category at all.
Okay.
So we're just making that clear in the plea form that that is not a charge that falls under 1020 life.
Okay.
And there is no minimum mandatory under that charge either.
okay. So you're entering this plea here today, Mr. McKinney. I just want to make sure you understand. I know you've got two experienced attorneys, and I'm sure they've gone over this in detail with you, but I need to be comfortable that you have gone over this and that you're, one, that you understand what you're doing here today, and two, that you're doing it freely and voluntarily.
Yes, Your Honor, I
So
am.
at the beginning, let me just talk about what you're doing. So what you're doing essentially is a plea to the bench. So you're pleading to the no contest to the charge, but it's not based on a set agreement, right?
Yes, Your Honor.
You're going to come in with you heard the term PSI, pre-sentence investigation, and your attorneys are going to be arguing on your behalf for whatever amount of time or no time, et cetera. The PSI is going to make a recommendation, the state's going to make an argument. You're going to have an opportunity to have a full trial, not a trial, but a full hearing on this sentencing. But what you're not going to be able to do, short of if there's something untoward that has gone on, what I'm trying to do today, what you're not going to be able to do is withdraw your plea, okay?
Yes, Your Honor.
You're pleading to this, but the sentencing is being held to a later time. You can't go, gosh, that's a harder sentence than I thought. I don't want that deal.
Yes, Your Honor, I
Not
understand.
like that. You're kind of laying it out there. You're gonna be able to argue about it, but you're moving the ball pretty far down the road by acknowledging and having no contest plea here today. Do you understand that?
Yes, Your Honor.
So you understand that for this phase of it, this will be a final resolution. You're waiving the right, you're waiving actually several valuable rights. It's talked about in the plea agreement. It's the right to go to a trial, the right to contest witnesses,
the right to make the state prove their case beyond every reasonable doubt. You understand that? You're waiving all those rights?
Yes, Your Honor.
Yes? Do you believe it's in your best interest to do that?
I do, Your Honor.
Is there a factual basis for this plea, Mr. Shaw? or
Yes,
Mr.
Your Honor,
Wilson?
stipulated.
Okay, stipulated to, very good. And you've had all of your legal questions answered regarding this plea agreement?
Yes, Your Honor.
Do you have any further questions?
Not at this time, Your Honor.
And this plea agreement is being entered into freely and voluntarily here today?
Yes, Your Honor.
Do you have any questions regarding this agreement?
No, Your Honor.
Okay, very good. Based upon that testimony, the court will accept your plea agreement here today, and we're going to schedule the sentencing for February 14th, during which there'll be a PSI and which your attorneys will have, and you'll be able to go over in advance. Okay, any questions? Anything further, counsel?
No, Your Honor.
Nothing from the state.
State? Okay, thank you very
Thank you.
much.
Madam Clerk. Judge, the
What
only...
about Hartzog?
Yes, sir. Jesse? Judge Tim Shaw for Jesse Hartzog. It's 20 CF 2976. We have had several discussions with the state, including as late as yesterday. We do not have a resolution as of yet, so we would ask for a continuance on that matter.
The state has no objection, Your Honor. As Mr. Shaw said, we have been speaking as recently as yesterday on Mr. Hartzog's case.
We want to just do a pretrial?
Yes,
The next
Judge.
pretrial?
Yes, Judge.
Okay, the next pretrial is December 28th.
28th or 27th, Your Honor, he's not incarcerated.
Correct. Thank you. 27th for non-inmates.
Thank you,
9
Judge.
a.m.
Thank you,
Thank
Your
you.
Honor.
I think that's all you got, Mr. Shaw.
That's all I have, Your Honor. Thank you.
Thank you. I think that's all the privates we have. You have one? Come on. Nitsky.
The first one's at 5 years. How much did the court cost prosecution?
Put it in there. Number 4.
What did it go? How much is court cost?
Probably 415.
Sign right there. Thanks, sir. If I may approach your office.
You may. Thank you.
Judge, on Mr. Maurice Anthony Nitsky, 22 CF 2244. Judge, he is charged in count 1 with a third-degree felony, and in counts 2 through 19, he's got 8 separate counts of the misdemeanor conservation, torment or deprive animals. Those are misdemeanors. And so the plea agreement is that he's going to plead no contest as charged, and that he is going to be placed on, he's going to receive 11 months and 29 days in the county jail, followed by 2 years community control, followed by 8 years probation. So I understand from these misdemeanors that for us to be able to get to the 10 years of supervision, the court's probably going to have to sentence him to the misdemeanors consecutive, I guess, because I don't know how we get to the 10 years. I wrote the offer the way exactly the state made it, and my client accepted, but then she just pointed out to me, I don't know how we need to put it.
Good point.
Judges, the state's intent for count 1 to be the 1129, followed by 2 years of community control, and then count 2, 1 year of probation consecutive to count 1, and then count 3, 1 year consecutive to all the other counts for a total of 8 years on probation. So the way I wrote it on the offer sheet, it should be counts 2 through 9, he should be on probation consecutively. The rest of the counts, 9 through
19.
yes, sir, should be credit time served.
That sounds good. I think that's the right way, Judge.
Okay. Very good. Okay, Mr. Nitsky, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Mr. Nitsky, just need to ask you a couple questions. First of all, a little bit of a unusual, complicated plea, so I want to make sure you understand it and that you're entering into this plea agreement freely and voluntarily. So first of all, did you understand what the plea agreement says? And I'll go over it again with you. I see that you've signed the written plea and sentencing agreement that kind of reflects the same issue. So what you've got, core of it, obviously, is the 1129. You'll get credit for time served, or I don't know how, whatever that is, that calculation, followed by 2 years of community control. That's a high, 2 years of community control is kind of like house arrest, right? You understand that?
Yes, sir.
And that'll be followed by 8 years of regular probation. Now, I'll order it exactly to make sure that it meets the qualification, because the 8 years of probation are basically the misdemeanors. So I'm sentencing you on the felony to the 1129 plus the 2 years of community control, and I'm consecutive, in other words, on top of that, you're getting the 8 years of probation, which are the misdemeanor charges. Is that your understanding of what the plea agreement is, and are you in agreement with that? Okay. You understand that by entering into this plea agreement here today, this is a final resolution of your case, waiving the right to go to a trial and contest all these things. Do you understand that?
Yes, sir.
You believe it's in your best interest to do that here today?
Yes, sir.
Why? That's a hard question to ask, really. I know it is, but
To be completely honest, I'm tired of being chained up like an animal and being brought here. I have a trespassing at that residence, and the police told me I was not allowed back over there. So I didn't go back there, and I still get arrested for animals at a residence that I'm not allowed at. And I'm told I have no way of winning this, so there's no point in me continuing to fight for this if there's no way of I'm winning it. When I'm doing what I was told to do.
Even though you don't really agree with it, you believe that the state would be able to prove their case. Is that why you're entering into this plea? I just want to understand it. You have a right to do that. There's no right or wrong answer to why you're doing this. I just want to make sure I'm exploring it so that I can come to the conclusion that you're entering into it freely and voluntarily.
I'm just ready to get it over with. I don't understand all of this, but I'm just ready to get it over with. I'm tired of going back and forth.
You said a magic word there that I got to explore. You said, I don't understand it.
I'm just ready to get it over with.
I know, but I want to make sure you do understand it. Do you understand the terms of this plea agreement? Yes?
Yes, sir.
It's the 1129 plus 2 years community control followed by 8 years. You got that? Okay.
Yes, sir.
Okay. And you have had all your legal questions answered from your attorney? Are you satisfied with your legal representation here today? Okay, very good. Based upon that testimony, the court will accept your plea agreement. As to count 1, the court will
sentence you to 11 months, 29 days in the county jail, followed by 2 years of community control. As to the 18 counts of conservation violation, the first 8, which is 2 through 9, counts 2 through 9, would be 1 year of probation for each of those. They would be served consecutive to each other, consecutive to each other and consecutive to the community control. Okay? Did I say that right, Mr. Nopes?
That's correct, Judge.
Okay. And then the remaining charges, so 10 through 19, credit for time served. Those are done as of today. Okay?
Yes, sir.
Very good. And there will be, you also have court costs and fees that will have to be paid during the course of the probation, and you can't, not allowed to own animals or be with 500 feet of animals. I don't know. Is that right? Can't be within 500 feet of animals? Defendant, I'm reading from the plea agreement, the defendant cannot own any animals or be within 500 feet of any animals. Is that correct, Mr. Nitsky? Do you understand that, Mr.
Domestic
Nitsky?
animals also.
I'm sorry?
I mean, if he's walking down the street and there's a dog, that's not in violation, correct?
He has to stay
According to this, it is.
Yes.
Right. If he walks down the street and there's a squirrel, is that a violation?
Oh, you want us to specify domestic, right,
Domestic.
domestic animals? That's
We're not
fine.
gonna send a
Catch
violation report,
everything.
but I know Maurice, and Maurice loves dogs. But I see him walking around with a dog all the time. And I don't want to put Maurice in that position where I
Domestic.
see him walking around with a dog, or I pull up to a house and there's 4 dogs around Maurice. Is that a violation?
I believe it is.
Let's enter this plea.
Domestic.
Let me come.
I share the concern, but that's what was pled to.
Plea agreement.
And I've supervised Maurice before, and he's been compliant with me, Your Honor.
I'm the neutral guy here. I'm accepting a plea. I'm not making it.
Judge, we're gonna hold back. We had agreed to put it on December 1st anyway. It's him waiting till December 1st for us to tweak everything isn't costing, he's gonna be in jail anyway. So, I mean,
I do think it's important. And look, I'm not getting in the middle of this negotiation. That's not what I do. Everybody understands that. The only thing I would suggest, and I say this about all plea agreements, is when we're doing plea agreements, try to look at making sure they're clear and they don't set the defendant up for failure. In other words, that there isn't some kind of a tricky gotcha. Now, I am a little bit concerned about this because of the fact, exactly what Mr. Berry said. He's walking down the street, he's walking past a house that has some dogs across the chain link fence right there. Is Mr. Berry going to file that as a violation? No, probably not. But is he in technical violation? Yes, he is. And that's not, we shouldn't be having things in agreement, plea agreement, where we're actually violating it. Anyway, I'm going to give you this back.
Yes, sir.
Just see if you can kind of come up. Anyway, we're going to continue this to December 1.
December 1st, Judge.
December 1st.
Thank you.
Thank you, Mr. Nopes.
Will that be at 9 a.m.?
9 a.m. No, yes, thank you, madam.
Yeah, I mean, that's fine. But it's not only, it should be at
Romero Garland, Ms. Etheridge?
Yes, Your Honor. Casey Etheridge for Romero Garland, and Your Honor, we're here in 2021 CF 2740. Mr. Garland would like to withdraw his previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer of a referral to pretrial intervention program. May I approach?
May. Garland, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement, which is a pretrial intervention referral, and that's what's listed on your plea agreement, which you've signed. Is that what you're agreeing to? Is the state in agreement with
Yes, Your
that?
Honor.
And you understand that this is, would be a final resolution of this case? Now, the intervention, you've got some more work to do, but the actual plea would keep this from going to trial unless there's a violation of the pretrial intervention. Do you understand that?
Yes, sir.
And you believe that's in your best interest to do that?
Sir.
Based upon that testimony, the court will accept his plea of the PTI referral. Thank you.
Thank you.
Colton Keaton, you need a control date for the pretrial intervention?
I don't think so. He's right here. It's usually we have the control date for them to meet with them, but they're doing it right now, so we're fine.
Yeah, what we'll do is we will send him over to the office, we'll instruct him, we'll get him to sign it, and then we will turn around and email.
What's that?
Would you like a control date? Because I'm not receiving it.
Yeah, we are. They're going to walk it over today.
He's gonna go over to the
It's gonna go
probation
right
office
now.
right now.
It'll be e-filed before the end of the day.
If you filed today, is that?
Well, we usually do a control date and then it's e-filed and we take it off the docket just to make sure that it's filed. But
That's fine.
That's fine.
That's fine.
What control date you want?
December, your next December date?
December 1?
The first, yeah.
Okay.
We'll have it done today, Judge.
Okay, thank you. We're just so efficient, we don't know how to have these.
Casey Etheridge for Colton Keaton, and we're here in 2021 CF 2013. Mr. Keaton would like to withdraw his previously entered plea of not guilty and enter a plea of no contest and accept the state's offer. In count one, it'd be adjudication of guilt, 30.6 months in state prison with credit for all time served, and he would be designated a sex offender. And in count two, adjudication of guilt, 5 years of sex offender probation consecutive to count one, cost of supervision waived, $666 in court costs, $100 cost of prosecution, $150 in public defender fees. He must complete sex offender counseling, no contact with minors until after the sex offender counseling is complete. And once the sex offender counseling is complete, the defendant may have supervised contact with minors, may not use or possess any internet-capable devices. Defendant will be fitted with a GPS monitor prior to release that will be paid for at the rate of $1 a day. The defendant will also be subject to a curfew from 7 p.m. to 7 a.m. that may be adjusted by probation for work purposes if necessary. No automatic conversion to administrative probation or automatic early termination. Count three, adjudication of guilt, 5 years of sex offender probation consecutive to counts 1 and 2, same terms and conditions. May I approach?
You may. State in agreement with that
Yes, Your Honor.
in the score sheet?
No objection, Your Honor.
Mr. Keaton, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state in detail the terms of your plea agreement.
Yes, sir.
Is that your understanding of what the plea agreement is? And are you in agreement with that?
Yes, sir.
And I see the same thing is written down in your plea and sentencing agreement, which I'll check, and which you have signed. Have you gone over this plea and sentencing agreement with your attorney in detail?
Yes, sir.
Make sure you had all your legal questions answered. Importantly, you're waiving a number of legal rights, and the main ones are dealing with your trial. You're waiving the right to go to a trial, to confront witnesses, et cetera, make the state prove their case beyond every reasonable doubt. This affects your appeal right? All those things are being waived in order for you to enter into this plea agreement. Do you understand that, and are you okay with that?
Yes, sir.
Okay. And you believe it's in your best interest to enter into this plea here today?
Yes, sir.
And you have had all your legal questions answered?
Yes, sir.
Is there a legal stipulated, there's a factual basis
Yes,
for
Your
the
Honor.
entry of this plea?
Yes, Your Honor.
This is not a downward departure. I see it's the minimum guidelines for the DOC. Very good. Based upon that, the court will accept your plea agreement and will sentence you, the core of which is the 30.6 months in the Department of Corrections. You will get credit for all time served, and there will be a sex offender designation. There's a number, count 2, will be 5 years of sex offender probation, number of costs and other specific requirements, including the GPS monitor prior to release and curfew. In addition to that, as to count 3, the 5 years of sex offender probation consecutive to counts 1 and 2, all of which are contained in this plea and sentencing agreement, the other details that were set forth by your attorney and are contained in here. Do you have any questions?
No, sir.
Okay, thank you very much.
And, Your Honor?
Yes, sir.
It is okay if we adjust that curfew accordingly as,
It's in the plea agreement.
okay.
That is correct.
And the state will submit a sex offender order to Your Honor.
Thank you very much. Antarius McLean? Is this a plea, right?
No,
What-
sir.
What is this?
Nelson hearing,
This is a Nelson.
but he may withdraw it.
Okay.
You can just go down the list if you want.
I'll show you, I'll tell you. Is Mobley is
A bond hearing?
a bond hearing, and then, yeah, that's,
And then I added Daniel Whitted, Judge. He's on your 2 o'clock docket for this afternoon, but he is a plea.
okay, you want to do that this morning?
We can, yes, sir.
Did you get those two? Mobley and Whitted.
Judge, this is Charles Russell, Public Defender's Office. This is Antarius McLean, present and approaching. Case numbers are 21 CF 1192, 21 CF 1484, and 21 CF 2777. We had set Mr. McLean's case for a Nelson hearing today. I went in the back and explained to Mr. McLean that his cases have been reassigned to Mr. Williams, who has recently joined our office, and I let him know he can either go forward with the hearing, I'm prepared to do that, or he can give Mr. Williams a chance.
I give Mr. Williams a chance.
I'm sorry?
I give Mr. Williams a chance.
Okay, very good. So, Coral, just note the withdrawal of the Nelson hearing. If you have a right to a hearing if you feel like you're not being properly represented, so you're not going to be, your withdrawal of it isn't going to affect your ability to do something in the future, okay?
Thank you.
Okay, so what's our next hearing for Mr.
He's already
McLean?
set for 12/28 pretrial conference, Judge.
Okay. We'll continue to 12/28. Or it's already continued.
Yes, please. Charles Russell, Public Defender's Office. Mr. Mobley is before the court on case numbers 20 CF 1650, 22 CF 1755, 22 CF 1757, 22 CF 1764, and 22 CF 2048. So, Mr. Mobley has been incarcerated since July the 9th. In his 2020 case, 20 CF 1650, he has a no bond. He had missed a court date, and the court issued a capias, and he has a total bond of $68,000 cash or professional in his other cases. Mr. Mobley has lived in this area for 41 years. If released on bond, he would reside at 5064 Pasco Broxton Circle in Holt. He's single, but he does have a child, 19 years old, who lives with him. Mr. Mobley is a high school graduate. He has also indicated to me that he would be willing to wear a GPS monitor if so ordered by the court. I do have a couple family members if the court wants to hear from them.
Let's, before we do that, let's.
Okay.
Judge State is objecting to the defense's request. This defendant was released in 20 CF 1650. In that case alone, he failed to appear for his court dates twice. While he was out on FTA status, he committed several crimes. I think we have 5 cases before the court. In one of the cases, he was so desperate to get away from law enforcement, when law enforcement located him on a stolen boat, that he dove into the Yellow River and successfully swam away from law enforcement, and where he made his way upon another stolen boat, and he got away. He is a flight risk. He's a danger to the community. He was out on bond on possession of a firearm by a convicted felon, and when law enforcement located him, he also had another firearm. He is charged with very serious crimes. He has a history of failing to appear. He fled from law enforcement when they finally arrested him on all of the crimes that he had racked up. He attempted to flee from law enforcement on a lawnmower. He has several charges ranging from grand theft, carrying a concealed weapon by a convicted felon, possession of a firearm by a convicted felon. He scores significant prison time, and based on the fact that he is a flight risk and a danger to the community, the state would ask that the fines remain the same.
One other issue, Judge, if I could, that I didn't bring up earlier. Mr. Mobley's father is currently in the hospital and in need of a transplant. This Mr. Mobley may be a match for him. We don't know that yet. But that would be something else that he would also bring up to the court, is that he would like to get out to help his elderly mother and then also possibly be an organ donor for his father.
It's not even a close call. Court's denying it. At some point, safety of the public is more important than convenience of the defendant. Denied.
And he's already set for the 12/28 docket too, Judge.
Very good. Whitted.
Judge, if I could have a moment.
Have a case number, Ms. Rivers?
Yes, Your Honor. It is 21 CF 3051.
What are the charges?
It's violation of probation.
Judge, we've reached an agreement on Mr. Whitted's case. As indicated by the state, it's a violation of probation. In exchange for an admission of the violation of probation, the recommended sentence is going to be revoke and terminate the community control that he's on. On count 1, it would be an adjudication of guilt. He'd be sentenced to a new term of 18 months community control with the original conditions. Cost of supervision would be waived. He would complete the Keaton program. He has already been accepted, but it would be bars to bed. He would pay a $100 cost of prosecution, $150 public defender fee, and $422.75 to the Okaloosa County Sheriff's Office for the cost of transportation, and 42 months of DOC time would be suspended on count 1. Count 2 is a second-degree misdemeanor. That would just be an adjudication of guilt and time served. And I have a score sheet.
State in agreement?
Yes, Your Honor.
And defense okay with the score sheet?
Yes, Your Honor.
Mr. Whitted, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement, which I see is also contained in the written plea and sentencing agreement that appears that you've signed. Are you in agreement with this?
Sir.
And you understand the terms of this plea agreement?
Yes, sir.
You understand that by entering into this, you're waiving the right to go to a trial and contest all this and fight this?
Sir.
This will be a final resolution of this violation of probation. You understand that?
Yes, sir.
Got all your legal questions answered of Mr. Russell? Make sure you understand what's going on here?
Yes, sir.
And you believe it's in your best interest to enter into this plea?
Yes, sir.
Do you have any further questions? Okay. Based upon that, the court will accept your plea of an admission on the violation of probation. The probation, revoke and terminate probation. Count one, there'll be adjudication of guilt and a new term of 18 months community control with all the original conditions. Waive the cost of supervision, complete the Keaton program, bars to bed, and then the other fees and costs. There'll be a 42-month DOC sentence that will be suspended. That's all as to count one. Count two, adjudication of guilt, time served. Okay? Very good. Thank you very much. Okay, and Mr. Williams, I think we've got Davidson Marquise, let's see, Marquise Davidson, Joshua Marquise Davidson.
That's correct, Your Honor. I got a hold of Mr. Davidson, advised him of the court date, asked him to provide documentation to our office. I did check on my way over here, and we'd not received anything.
State would ask for a KPS with no bond.
Court will issue a no bond capias.
All
Appreciate
right,
your
Judge.
follow-up on that, Mr. Williams.
Certainly, Judge.
Okay, I think that's all of our non-trial.
Your Honor, we have several more pleas,
Oh, yeah?
so just
do you
so
got?
the court's aware.
I'm sorry.
The rest of
My
mine are
list,
all
I don't have
pleas.
any more.
The rest of mine are all pleas, Your Honor.
On this docket?
Yes.
Okay. Let's, William Ewing, is that,
Yes, Your Honor.
Tarpley? He is here.
You may have to pass him for a moment, Your Honor, because I believe the state needs to need to. Do you need a second, Lisa? Okay.
we need to
I think we're going to pass Mr. Hewing.
pass Mr. Ewing?
Yes. Yes, Your Honor, please.
Gafford, Matthew Gafford?
Yeah, that's fine. Casey Etheridge from Matthew Gafford, and we're here in 2022 CF 612. Mr. Gafford would like to withdraw his previously entered plea of not guilty and enter plea of no contest and accept the state's offer. For count one, it would be adjudication of guilt, 5 years in state prison with credit for all time served, followed by 2 years of probation, cost supervision waived, $767 in court costs, $100 cost of prosecution, $150 in public defender fees, no contact with Brian Nichols, $640 in restitution to Brian Nichols, early termination after 1 year of probation if restitution is paid and there have been no violations. And on count two, adjudication of guilt, 5 years in state prison with credit for all time served, followed by 2 years of probation concurrent with count one, same terms and conditions. May I approach?
May. Is that the agreement from the
Yes, Your
state?
Honor.
I signed for my BOP, am I going to get the 8 months that I've done and counting from the date of my arrest?
Yes.
Okay. And you say it on, you say it 20 months, so it's on like cryptography or whatever?
You get credit from your arrest March 6th.
From March 6th?
Yep.
Okay.
The defense okay with the score sheet?
No objection.
Mr. Gafford, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? So you heard the terms of the plea agreement
Yes, sir.
that your defense counsel said. You can put your hand down. Just want to make sure you understand your plea and you're entering into it freely and voluntarily.
Yes, sir.
So, terms of the plea agreement I see also is contained in your plea and sentencing agreement, the written form, and you've signed that. Have you gone over this and gone over the terms of it
Yes, sir.
in detail with your attorney?
Yes, sir. I just want to make sure on record that I'm getting all credit for time served for this charge from my arrest date on forward.
Okay.
On the two charges.
First of all, I'm going to say to you, you're asking a legal question, I'm going to give you a legal answer.
Yes, sir.
You will get credit for all time served, okay? Even if it's not contained in here, you would get credit for time served, but it's contained in here as well. I'm not here saying exactly when that is. I don't know what that is. That's a calculation that's actually not done by the court. It's done by the jail.
Sir.
So you will get credit for all time served, but I can't assure you, yeah, that's the exact date you'll get, because I don't know.
Yes, sir.
Does that affect your plea here today? Are you still willing to go forward?
Still willing to go forward, sir.
Okay. So you understand that by entering this plea, importantly, this will be a final resolution of this case.
Yes,
You're
sir.
waiving the right to go to a trial, contest all this, force the state to prove their case. You're waiving all, you believe it's in your best interest to do that?
Yes, sir.
And have you had all your legal questions answered from your attorney about this plea here today?
You are no HFO, right?
No, you're not pleading to
Yes,
this, no.
yes, sir.
You believe you've gotten good representation on this case?
Yes, sir.
Do you have any further questions?
Sir, Your Honor.
Based upon that testimony, the court will accept your plea as to count one, burglary of a dwelling with assault or battery. There'll be an adjudication of guilt, 5 years in state prison with credit for all time served, followed by 2 years of probation, cost of supervision waived, court cost and fees as contained in your plea agreement, no contact with Brian Nichols, and $640 in restitution to Brian Nichols. Early termination after 1 year of probation if restitution is paid and there are no other violations. Count two, adjudication of guilt, 5 years in state prison with credit for all time served, followed by 2 years of probation. This will be done concurrent with count one, same terms and conditions as count one. So these will be concurrent sentences, not stacked on top of one another.
Sir.
Any questions?
Sir, Your Honor.
Thank you very much. Jonathan Johnson?
Casey Etheridge for Jonathan Johnson. If I may have one moment, Your Honor. If we could reset Mr. Johnson to the first. He just needs to, ask me some questions that I don't really have time to answer today, so I'm just going to go over and make sure he understands everything before he pleads. This case now was, apparently there were, I don't know if it was a miscommunication or if I didn't say it correctly on the record or whatever, so there were no subpoenas sent for this case anyway, Your Honor. And so we would not be able to go to trial this cycle.
That's correct, Your Honor.
So,
I mean, you
But I
did
believe we
announce
have a
ready for
resolution.
trial, so I assume that there were, but
we have a resolution, Your Honor, so I
You-
believe so.
yeah, we can't go to trial, so all I can do is yell.
Yeah.
So we'll come back on December 1st. Hopefully, there'll be a resolution. If not, we can continue it for trial.
Yes, Your Honor. Thank you. Yeah.
Thank you.
December 1st, now it's 75 in the morning.
Okay. I mean, whatever Your Honor would prefer. The 8th is fine, it doesn't.
Let's start tracking them on the 8th. Thank you for letting me know that. Actually, my successor will be, thank you.
It's a draw.
Okay. He can go ahead and come out, it's fine. Yeah, he can come out, we're ready, yeah. Casey Etheridge for William Hewing, and we're ready for trial.
Okay, so we're getting the pleas out of the way, so let's go ahead and ask you to,
Minor.
and just hold on, just hold him. We'll continue to come. We'll come back in just a
We're
second.
going to come back in a second.
Trying to get a couple other cases done, and then we'll take a little more time.
Your Honor, I do have one with Ms. Gooden, Benjamin McNutt.
Okay?
Your Honor, Mr. McNutt's case, I believe they are still announcing ready for trial. However, I have advised Ms. Gooden that unfortunately my victim is currently in an institution and unavailable. We are still discussing a possible resolution, though, so we cannot go to trial at this time. But we would ask the court, if we do come to a resolution, could we potentially take care of that next week during the trial week? In other words, bring him in for a plea if we come to a resolution. But we do have to ask for a continuance based on the unavailability of our victim.
Why don't we do this? Why don't we, let's go ahead and so, let's assume there's no resolution. What do we do? Just put it on pretrial?
Yes, Your Honor.
Go back into the regular
That is
session?
our request, and I'm not trying to speak for Ms. Gooden here.
Ms. Gooden?
Pretrial is fine, Your Honor. I mean, we object to the continuance. My client was jailed and spent some time in jail. He's had extreme expenses, rented a hotel room for the week, getting ready for trial, but state can't help the unavailability of its witness.
And that is why we're trying to see if there is a resolution that we would take care of it while he's still potentially here.
Okay. Okay, it seems we don't know exactly how next week is setting up. I would say yes, let's go ahead and schedule a hearing for just a regular pretrial on 12/27. And just say to you, if you get a resolution, we'll figure out a time to do it next week, but I don't know what that is.
And we'll reach out to your assistant if you wish.
We'll figure it out. Yes, we can find a time next week, whether it be over the lunch hour or before we start or whatever, to accommodate him not having to, come back and travel back down.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Ms. Gooden.
Okay. So, Mr. Russell,
Yes, sir.
are any of yours, any other pleas? That's, I guess, my question, before we start with, the rest of mine that I've got are ready for trials.
Do you want to take care of McQueen, sir?
We can. No other pleas, Judge, but we do have some issues.
Which case?
It's David McQueen, and he is
McQueen?
1989, sir?
page 9 of your docket. Yes, sir. Charles Russell Public Defender's Office, Judge, this is David McQueen, 21 CF 1989. Judge, we had previously announced ready for trial. The state's last offer in this case was 5 years in DOC, followed by some probation. I have talked to the state attorney this morning. Mr. McQueen has no prior record, so we were trying to get something a lot less than that or just strictly probation. The state said that they might be open to consider something like that, but they would want to have a psychosexual eval, and they're not promising anything, but if they see a psychosexual eval that gives them some comfort, they might be able to come up with a better offer. So we're asking for a continuance to complete a psychosexual eval.
There's no objection from the state, Your Honor.
So we put it on the next regular pretrial, 12/28,
Yes, sir, because it's going to take a little while to get
and
the eval.
we'll just let you all have to process the ordering of the
Yes, sir.
evaluation.
We'll take care of that, Judge.
Thank you.
Okay, very good. Thank you very much. Hold on just a second. Okay. I count 6 cases. One of the cases that we want to begin with, obviously, that we've had some changes is Larry Jack Miller. You want to do our pretrial on that first? I mean, our jury
Your Honor, there
review?
is an issue on the Whitaker case that we need to bring to the court's attention as well.
Okay.
But we can do
Let's
those.
start. No, I want to do everything before we do our jury reviews. So, we just got out of order. I thought we were, that's why I asked. So do we want to do are there any other issues other than jury reviews?
Your Honor, in Mr. Whitaker's case, Mr.
Okay.
LaPella is present there. He, as late as yesterday
Sorry, Mr.
afternoon-
Miller, I'm
sorry,
trying to
Mr.
get
Miller.
over, it's my fault. Give us just a second. Come, we'll be with you in the next case.
And let me grab that one. Your Honor, in Mr. Whitaker's case, Mr. LaPella filed yesterday afternoon at about 4:45 several motions in limine. Additionally, he did file some additional reciprocal discovery. The motions in limine, while they are of concern and need to be taken care of before a trial, what concerns us more is the reciprocal discovery. We need an opportunity to determine the authenticity and the validity of the reciprocal discovery and also the relevance thereof. That would require, in this case, it's a,
Is there not timelines, requirements for reciprocal discovery? Is this newly discovered evidence?
No, Judge, the rule is 10 days. What we uncovered was there was a friend request by the victim to my client's father.
There was a what? A friend request?
Friend request. So the state
Like
can...
on Facebook friend request?
Yeah, and so we're just verifying, the state can verify that by just a phone call to their victim. Did you send a friend request to the victim's father, yes or no? And then if she says no, but I don't think she's probably going to say that.
Your Honor?
It's an easily resolvable issue for the state. I think the state's just trying to delay the case.
Your Honor, first of all, something that late on discovery, that this friend request, if it is in fact authentic, was from May of this year. So for it just to be filed yesterday, I'm not going to say they're trying to delay us, but the state, in order to authenticate this, will have to go to Facebook. Facebook will require either subpoena or a search warrant to get that. That is how to properly authenticate something like this, and that's what we really need to do. And then we need to see whether or not it has any relevancy. First of all, it's not to the father, it says April Whitaker on it. So again, we don't even know, based on what Mr. LaPella said, what the relevancy is, if it's authentic. But the proper way to authenticate something like this is through the agency.
I'm a big believer, you all still kind of getting to know me, and I'm getting to know you. I'm a big believer in laying our cards on the table. We're not playing hide the pea here. So, you're asking to delay it?
We'll withdraw the reciprocal, Your Honor. If it's going to delay the case because the state can't make a phone call, then we'll withdraw it. We won't use it.
It has nothing to do with the state making a phone call, Your Honor.
It's-
It's a proper authentication of evidence. Mr. LaPella has now raised it. Even if he says he's going to withdraw it, unfortunately, we've gone through this before in a different case where the state removed a witness and Mr. LaPella insisted still that it may still be relevant, so we need to go forward. So he's raised this.
That's not true, Your Honor.
We need to authenticate it and determine if there's any relevance.
The state is attempting to delay the case because she has 5 or 6 cases set this month, and that's why the state's looking to delay.
Okay.
There's no rational basis for the state to have to go through Facebook to verify if someone had a friend request. What can happen there is the way it plays out, and I'll just say it, we ask the alleged victim if they made a friend request, what was the purpose of that friend request, and then they can say, no, I didn't, or yes, I did. That's it. So if that's not an issue at all and the state doesn't think it's an issue, then we'll withdraw it. If it's so important to the state to delay this case, then they will still want the continuance. And in fact, I believe the state still wants a continuance, even if that's no longer an issue, which exposes the fact that their request for a continuance is purely for delay. That's the plain and simple fact here, Judge. And I think the court needs to take these things very seriously, and it needs to...
Court does take it very seriously,
Okay.
counsel. You can be assured of that. I'm going to take a little break.
Thank you.
Thank you.
All right. Need to get, let's bring Whitaker back up. Based on the 11th hour discovery request, court's granting the motion for a continuance. State has a right to try their case the way they believe appropriate. When you raise an issue, they've got to deal with it the way they deal with it appropriately in their mind. And best way to do that is not to have 11th hour discovery issues. So we'll continue it to the next cycle. We'll go from there.
Thank you, Your Honor.
Come back on 12/27 for pretrial.
So the court's undertaking a Richardson inquiry on this case and determined that the state would be prejudiced, is that correct? 10-day rule, non-applicable in this case. Want to make sure.
Counsel?
Your Honor, first of all, the trial week starts next week, so we don't even have a 10-day rule here.
We weren't available till the 21st, Judge, and we made that clear on previous court dates. 21st is the only week that we could try this case. That's outside of 10 days.
I specifically said that we weren't pre-setting them, so.
Judge, for the record, I cannot be prepared to not know what week we're going at this hour. We're on a Thursday.
Mr. LaPella, we aren't going, so you don't have to worry about it.
Well, in the future, Judge, it's totally, it's untenable for us to not know.
Counsel, I've got probably 100 defense attorneys. You know how many have raised that issue? None.
Are we
Except for
supposed to
you.
issue
So,
subpoenas?
hey, I'm just playing by the rules. I didn't set the 2-week jury schedule. That was set previously. I inherited that, and that's the way we continue. Sometimes we set them, sometimes we have to do. The purpose of the 2 weeks is to make sure everybody can get fit in better. It's for everybody's benefit. So I can't promise you that I'm going to always go the week you want to go because you have something else planned. I can't do that.
I got to issue subpoenas, and I got to know which week we're trying the case. I can't have witnesses on a 2-week, on 2 different weeks of availability. I can't verify
Well, I mean,
that.
there may be times when we do that, but we're not going to have to worry about it on this case.
Okay, well, I'm objecting, and I invite other defense attorneys to object to the calendar as well. Thank you.
Okay. We'll come back on December 27th for jury pretrial.
Thank you.
Thank you. Okay. Any other issues that we have to deal with before we kind of start going through some of our jury reviews?
Yes, Judge.
Let's pass over Miller, and let's look at Garlow.
Carol Goodman for Elton Garlow, who's approaching the lectern, Your Honor.
So this is case number 2021 CF 546, and it was announced ready for trial. Is the last plea offer, has that been,
That had been formally revoked, Your Honor, and the state had submitted some preliminary instructions previously. I do have another copy for the court, as long as it's with
Be helpful.
a verdict, if I may approach. I provided it previously to defense. The only major change from the ones provided would be the reclassification. I was searching the bar website yesterday and did not find those on the website, so the reclassification language in the verdict form and within the instructions are from State v. Bachman that Ms. Basso has used.
the reclassification? Let's see, where is that in your,
On the verdict form, it's the bold language between every count, and then within the instructions, it's in the final instructions. Under counts.
where is it in the verdict?
On the verdict form, Your Honor, underneath each count,
Yep.
it's the, if you find the defendant guilty, you must determine the following underneath each, which is the reclassification for the enhancements.
Right.
And then in the final instructions, after statement of the charges, there's the counts. And at the end of the language about counts, including possession, control, et cetera, I put in some language as far as the enhancements from the statute and from the Bachman case.
Okay, do you note on there that it's from the, I'm just trying to, having a hard time finding exactly all the things you're saying. Why don't you make a note on here, just so. I'm particularly interested in is anything that is not a standard jury instruction.
Right.
You look through the control.
It's page 10.
The language for
Right,
punishment and then this.
right. I think it's page 10, Your Honor,
Okay.
in counting through.
And obviously, not obviously, but we, you know, we don't have to make any final decisions today, but if there are issues that are out there, just making the court aware of the issue is helpful to me. So, do we have, or is it anticipated that there are, exhibits? Have we exchanged exhibits?
There has not been an exchange of exhibits, Your Honor. Obviously, one of our exhibits is going to be the child pornography itself, which my office doesn't keep and I can't give to Ms. Gooden.
So you can and can't?
I cannot give the child pornography to Ms. Gooden, and I obviously don't have it on my person either.
But our experts have gone.
Okay, have gone over it.
Correct.
Sure. Okay. I just want to make sure we're where we're at in the process mainly.
And Your Honor, one other thing that I did notice in the previous minute sheets, I'm not sure if Ms. Gooden has formally pled her client not guilty on the second amended information filed by the state July 29th of 2022.
I was under the understanding that we did plead not guilty, but we would plead not guilty, waive formal reading, announce ready for trial.
Very good. Thank you for that
My,
clarification. I'm sorry?
my only objection to the instructions is the verdict form.
Okay.
It says, we, the jury, find count 1 through count 10 guilty of possessing photographs. The statute and the jury instructions read knowingly possessing, but I don't know if, to me, that would make a difference, because simply possessing or knowingly possessing is two different things.
Well, I wouldn't be comfortable putting it at this point. I will check the standard language and have either an argument or acquiescence before we pick a jury as far as which will be read.
Because 16.11, under counts 1 through 10, say Eldon David Garlow knowingly possessed. And here it's just a possession on the verdict form.
Why don't we just say that because this could have some impact on the presentation of evidence, I would just ask that we address it in advance of trial. I'm not asking you to make a formal, this is why we're doing this, so this is good, to raise these issues, but let's deal with them before. This is one that we might not wait until, after all the evidence, because it could impact the evidence.
Yes, Judge.
So.
I believe the only other issue in regard to the jury instructions would be lesser includeds. My understanding from the Florida Bar website, there are no Category 1s, and there's attempt under Category 2s, which are optional if defense would request them. I did not include them in this preliminary version.
I will go through with my client. He maintains not guilty, but I will discuss with him the benefits or the
Downside.
non-benefits
Sure.
to having lesser includeds.
Okay.
And then I will advise you.
Okay.
But at this time, I would say no.
Okay. Well, again, let's address that before we, when we reconvene at the start of the trial, but, outside before we pick.
Yes, Your Honor.
We'll go over that.
And Your Honor, not to stir the fire that was ignited earlier, I do have the 16th and the 18th open of next week. The 15th and 17th, I can get coverage.
We have Monday, Wednesday, Friday. I'm not sure which
Yeah,
days.
Monday,
Okay.
Wednesday. Monday is jury selection, the 14th. And then Wednesday,
How
I
long
am
do you
completely
anticipate
open.
this?
1 day.
One day inclusive of a
I don't
jury?
think we could do a pick and go. I think it would have to be a day
No,
plus
it'd
jury
be jury
selection.
selection and then
Yeah.
a trial.
Yes.
I don't think we could do a pick and go.
Okay. So when do you have?
I am available because you accommodated me with Judge Wells. I'm available all week. I have open the 16th and the 18th. But Wednesday and Friday. But I will do my magic and get rid of the other ones. I just didn't know what day the state witness, if they had a particular day.
I have availability, myself, of course, I have other things, but I can get coverage other than probably Thursday. I have some actual contested things on the docket. I can get coverage Monday or any deposition dates. I believe as far as my witnesses go, I am open, other than one of my witnesses who I anticipate will be my first, would not be able to get on the stand Wednesday morning before probably 9:30 or 10. But if we're going to do openings and things, I don't think that will be an issue. Perhaps we want to see what else is left at the end of this as
Yeah.
far as, okay.
Let's kind of see
Okay.
where we're at.
All right. So we meet Monday,
Well,
8,
let-
oh, I'm sorry.
That's what we need to see. We can pick the jury any day. So that's the answer. We're not picking all juries Monday.
Oh,
We're not
okay.
starting everything on Monday and then
Okay.
coming back for trials. We can do it however we want. We can pick them on, individual days, or we can go pick and go any, so.
There's only like 3 more cases.
Let's just see where we're at. If you'll just
Hang with us just a little bit. We'll
If I may, Your
resolve this
Honor,
this morning.
I'll need to go call because I had Judge Schlechter, and I need to make sure that,
And we'll be through with it this morning. We're not going to hold you over this afternoon. But you need, right now, I mean, you can go call.
I was just going to let you know I'm going to leave, but I'm not leaving.
Sure, that's fine.
Okay.
McDonald? Where are we at with McDonald?
Your Honor, the last time we were before the court, he had said he was hiring an attorney, but that he wanted to work things out. He and I went over specifics.
That's what he told you? 'Cause I
Yes.
don't remember hearing it, but
Yeah. Oh, okay.
maybe
May not
he
have.
did say that.
Yeah, he did say it, Your Honor, on the record.
Okay. So,
I'll grab.
good morning, Your Honor.
So this is case number 2018 CF 3447.
And Your Honor, he has a couple of cases.
Ms. Rivers,
Yes.
I have some documents here, and I have a good proposal. Because that is my mother. And these are the records. And I thought about, Bridgeway is not far from here. Bridgeway is, it's just south of downtown. It's off of, served on the 7th and 8th. I spoke to you about that.
So do you want to do the 3 years DOC followed by probation with inpatient treatment?
Eating the Bridgeway.
No, I told you I do 3 years DOC plus the probation that you need to do, but
If
as
I
said
go to
before,
prison, though,
I'm not willing to do less than 3. When you use 4.
I'm trying to go up under the irreparable harm doctrine. Be homeless and be back before you. Consider it, just think about it. I'm just trying to mitigate with you and negotiate, and please give me a little bit of leniency. I'm asking you for leniency based on the provided documents I gave you. Anything of that without the continuation of that. Be able to come back into society and be productive, because things have changed in my life that are very important. And just consider it, and I think I have court again on Monday in another restaurant.
So you want to continue it while?
Just, and let you think about this. Just give me an opportunity to present it on the facts and the plausibility of it.
You want to,
Your Honor,
I'm not following any of the, I wasn't really listening to the conversation.
Your Honor, says he's got court on Monday on another case.
Where? Here?
Civil.
Civil. Civil here?
Oh, no, sir, I think I have court in front of Judge Ward.
Oh, you got a criminal case?
No, misdemeanor. Which they've already gave me credit for time served, really. I wanted to do it. Also, I wanted to show you that I have support from family members here. Prior to all of these issues going on, that I have already had a predisposition to come to you with these proposals. And on the other side, today, forward to today to talk to you previously before any of this went on. The living relative.
So, where are we?
Your Honor, he's asking to continue to try to arrange some things and for me to consider some things.
So, what's the state's position? I mean, obviously, I know what his position is. He
Your Honor,
wants anything that's not a jail sentence.
Your Honor, the state has no objection to him to see if he can pursue other avenues. I'm not budging from 3 years. That's the lowest I'll go for DOC.
Okay.
He scores it.
Okay.
6 cases, it seems more than fair.
Okay.
Based on the last time we were in court, I was left with the impression that we weren't going, that it was being resolved, and what the terms were,
Last
and now
I
he's
understood
changed
the
it.
court, last I understood the court is that we were going. I had ready for trial.
Yes, and that he,
But
you know.
then maybe he said something after that I missed.
And then he, you know, there's specific terms were laid out, and I had drawn up the agreement, changed the score sheet for today, because it was supposed to be 3 years DOC plus 18 months probation with inpatient treatment. And now he's wanting to do different, less than the 3 years, so we're just not on the same page at this point. He's asking to continue, so that's fine with the state, but that's where we're at.
Are you ready to proceed to? Because it was announced ready for trial. Are you ready? Are you ready for trial?
The state can be, yes, Your Honor.
Mr. McDonald?
Yes, sir.
Now, you've heard, I mean, there may be some other terms, but the bottom line, 3 years DOC has been put forth, and I'm hearing that you're rejecting that. First of all, I want you to understand that I don't get in the middle of plea negotiations.
Yes, sir.
And certainly, you're not going to be penalized
Yes,
for
sir.
rejecting the state's offer.
Yes, sir.
But I just kind of want to see what your position is and see if you are ready to try to proceed to trial on your charge, or, you know, I mean.
My position before the court, Your Honor, is I have 26 and a half months already time served towards the 36 months. I presented the state with factual, official documents.
Mr. McDonald?
Yes, sir.
Don't argue your case, because I'm
Okay,
I'm not going to get in the middle of your negotiations.
Okay. I didn't.
If you want to accept that. Now, one thing you can do, you know, I mean, you can plead to the case, and we can order a PSI and
pre-sentence investigation, and you can argue before the court, and I'll make a decision, on the sentencing side. That's called a plea to the court. I'm not suggesting you do that.
Yes, sir.
But that's an option. I mean.
Yes, sir.
But I might go more than the 36-month DOC.
I understand that. It's pleading up to the judge.
He
And,
scores
and-
more
and-
than 36.
And usually that don't end well for the defendant. But anyway, I'm not trying to,
commenting.
I just wanted to, I proposed a good offer to her. I felt like,
But,
how about if we went to the county jail where I can...
Mr. McDonald, the thing about plea agreements are that, just like any other contract, it takes two people.
Yes.
You may believe it's reasonable. State believes their offer's reasonable. No, is anybody right or wrong? I'm not here making that. Well, you're right or wrong. An agreement has to be, that's why they call it a plea agreement. It's not a plea coercion, force. State can't twist the court can't twist the state's arm, say, yeah, it's a nice-looking gentleman here, you really ought to consider his offer. I can't do that. I won't do that. So, question is, what are we doing today?
I'm asking if I can come back on Monday or schedule as soon as possible. Give me some time to think about the proposal. I'm very, I don't understand why the state wouldn't want to work with me, because the likelihood is I'm going to be homeless with the imposed sentence. That's all I'm asking. I only live 9 blocks from here, and with imposing an incarceration, a continuation of the incarceration, puts me homeless, and I will be back before this court, and I'm not trying to do that. I'm trying to be a productive member of society as I once
I
was,
appreciate that.
and that's all I'm asking the court. I want to find who I was before.
I'm just trying to think what. We come back next week, we're essentially pushing the trial because all your subpoenas and everything.
My victim's not available the first week. He is available the second week.
Well, why don't we do this? Let's come back Monday morning. We'll come back Monday morning, and we've got coverage on Monday to cover a trial if we need it. We'll come back maybe the following Monday if we decide not to go forward, if the state changes their position, or if you change your position, we'll see where we're at. So we'll come back, we'll continue to 11:14 at 9 a.m. Actually, why don't we do it at 8:30? Because we may be having jurors coming in and whatnot, okay?
Thank you, Your Honor.
Thank you. Sure. William Ewing?
The authorized for Mr. Hewing, we're hearing it's 2021 CF 1763. He also has 2021 CF 1877. Do you want to approach her?
If we may approach, Your Honor.
Sure. Okay.
We were getting some guidance from probation too, so if you.
Okay, so we talked about different issues. We are tentatively prepared to proceed to trial on Monday, 11/21. So we just need to go through some procedural. When do you all anticipate being able to have some preliminary jury instruction? I mean, as long as you get them in, from my point of view, as long as I get them before,
14th?
you know.
Monday? This Monday?
No, you can do it, I mean, you don't have to do it that fast. I mean, as long as you get it in by, give me a couple days, to.
So by
Be
the,
re-
see,
Wednesday close of
16th.
business, Wednesday close of business, 11/16, close of business. You all have your exhibits identified and?
Yeah, sure, I mean, whatever we would need, yeah.
yeah, we'll have it by the
We'll-
16th.
Okay. And then are you all exchanging witness lists? Do you already have that?
We already have, Your Honor, I believe everything's been through discovery process.
Very good. Any other motions, or I know there's no outstanding motion, any anticipated
I don't believe
evidentiary
so,
issues or
Your Honor,
anything like
not, I
that?
mean, not that I can anticipate right now.
So if we do pick, just so we can, for the clerk's benefit, do general 30 jurors?
Yes, Your Honor, I
Standard.
believe that's appropriate, yeah.
Anything else we need to do on this case?
No, Your Honor. No, Your Honor, if I could just have one moment with him before they take him back, but, yeah.
One more to tell you.
Oh, sure. Yes, please, thank you.
Twenty first. Now, on McDonald, do we want to go ahead and schedule it for the 21st?
That would be, well,
And we're coming back this Monday to determine,
yes, Your Honor, that would be fine.
but just for the clerk's benefit, for scheduling possible jurors.
I would be able to have the jury instructions, everything ready by the 16th as well.
Okay. Yes, we're leaving it on the 4th, but we're actually setting the trial is scheduled for the 21st. And if both of them would happen to go that day, we'll probably pick the juries and then, do the trials the next day, or we'll decide if we wanted to do a jury the next day. We'll maybe look at it more closely on Monday. We can always change that. Okay.
Judge, can we approach?
You can.
Okay.
It was just, hold on just a sec.
2 months to do over there.
Judge, this is Larry Miller, case number is 20 CF 2061. Mr. Miller is present and approaching.
Okay, so we were just working, Mr. Miller, on some scheduling issues for next week, and we arrived that the best thing to do would be to, we'll pick a jury on Monday, and we'll begin the trial on Thursday morning. So we've already gotten some preliminary jury instructions. Is there anything else that needs to be done at this time as far as, do we have exhibits, witness lists, anything like that? Any other evidentiary issues that we need to address? We already obviously addressed the important ones, the motions in limine and the other motion that we dealt with.
State was going to get some more pictures or doctor the pictures they had, or?
And I'll have those on Monday when we come to jury selection. What we had talked about, Your Honor, was, for instance, taking Santa Claus out of the picture and the other girls. We'll have that to show Mr. Russell, I would think Monday, if that's okay. We're definitely not going to use it in jury selection anyway, so I will have it to him before we bring it to the court.
And the only other things I put on the record, Judge, we still have objections to the pictures, but also our preference, as we discussed at the bench, was second week because of the one witness problem. We still object to going the first week, but the court has ruled so.
We've got 2 trials already scheduled for that, so.
Work, and I think if Mr. Russell had anything else on the jury instructions, he was going to let me know.
I'll get with the state judge and work it out.
I appreciate everybody. I mean, everybody was making a good faith effort to try and get this on both counts, so we'll try and make it work.
Thanks, Judge.
So you're still on it.
Okay, Ms. Gooden?
Yeah, I wouldn't try to
For Eldon Garlow, who is present and approaching the lectern.
So based upon the other scheduling and whatnot, we will pick our juries on Monday, the 14th, and we'll begin this case on Tuesday.
I thought it was Wednesday, Your Honor.
You want to do Wednesday? Let's do Wednesday.
Please.
We'll do
For
Wednesday.
the state and I. Thank you.
I'll do Wednesday. That actually works better for me.
We do try to accommodate, Your Honor.
Okay. Well, I appreciate it. So, you're going to give me some, you've got the proposed jury instructions, so we've got that. Before we start,
Judge, we will look into the knowingly issue requested by Ms. Gooden, and I believe she said she would let me know if she wanted any Category 2 lesser includeds. Correct. So we will have those ready to go for
what's
Your
the
Honor.
second thing?
Any Category 2 lesser
Okay.
includeds that they are requesting.
Right.
And Judge, in a case like this, of
When are we
course-
going to when do you want to try and resolve those? Before Monday or before the start of the trial?
Before the start of trial would be fine. I mean, she can give me an answer Monday. I don't have a case law that says you have to put this in there. I just,
But you can still make arguments, and we'll figure out where we're going. We don't have to make a final determination until we're actually making final decisions on it, so.
Yes, Judge. And I do think it is only in the final instructions.
Right.
So the preliminaries wouldn't necessarily be an issue as well. Given it's a case of a sensitive matter, how big of a jury pool are we expecting?
I
That's a good question.
think 30 is.
I would ask for 40.
Okay.
I would say, yeah. At least. Okay, 40 jurors.
That was one thing, actually. Ms. Bosso, did Mr. Russell run out?
I think he just stepped out.
We actually had talked, Your Honor, we said either if 60 should do it, given the,
Do you think the 40 is sufficient for this?
for the child pornography. I would say, let's go with the 60 also, Your Honor. We had 120 last time, we probably don't need it for that.
I would say 60, I agree. What's that?
I just think when you have to ask questions.
I made
about
a bad
sex
joke,
offenses,
Your Honor. I
a lot of
said, you trying to
people
say
are-
they're closed-minded in Crestview?
No, that's, it's just,
You never know what the
we're
answer
trying
to
to
that
figure
question's
out.
going to be.
We just asked the question about a number of jurors.
Yes,
She
Your
said, Mr. Russell, as to Mr. Miller, Ms. Bossow said you all had discussed it and thought 60 would be a good number. So I agree. So I just
60
want.
for both to pick from? Or 60
Each.
60 for each, yeah.
Sounds good.
Yeah, yeah.
So, and is the plan to pick?
Yeah, that's a good question. Who goes first? Friday? It doesn't matter, Monday.
I'm here for both. So.
And so am I, so it does not matter.
Means that,
First.
Ms. Gooden, you want to go first? Monday morning?
Since their trial is.
For a picking jury. It's either in the morning or in the afternoon. Your choice.
What's better for you, morning or afternoon?
Doesn't matter.
It doesn't matter, Your Honor. We're good for either.
For the morning.
Morning's good.
Do it in the morning then. Somebody spoke out.
And then, so Judge, you would want us at what time? 1:30?
1:30.
1:30? We are picking from a separate panel from them,
That is correct.
but it might have some of the same people.
Yeah, it's a totally different set.
You wanted your own. We're giving you your own.
My understanding that it would be, the
The
clerk, that's a good.
Right.
Yeah.
That's right. I agree.
We're
We're doing separate pool.
Well, they're going to notify the person.
Thank you, madam.
Signed up for text messages.
Okay. Very good. So anything else that we need to do on this, Miss? Good.
On this case, no, Your Honor.
Okay. We will see you
Monday, 14th.
Monday morning.
8 o'clock, 9 o'clock?
We need the attorneys here at 8:30, and the jurors are asked to come at 9. So,
Okay.
we're just, if there's any last minute, just organization, just anything we need to deal with, we always want to be in a little before the jurors, so
Yes, sir.
keep their waiting to a minimum,
Yes, sir.
okay? Okay, we'll see you then. Okay, I
you.
think that concludes our morning.
Well, I need a note.
You need a note from Judge, what do we need to?
Judge Schlechter, and I emailed
So
him.
he wouldn't believe you if you told him you were here?
I don't know, I got the Ms. J.A. saying, because you weren't in court this morning, you better be there at 1:30. I'm like,
Time to watch Crestview Court TV.
I was gonna say-
Whenever you need me to write you a note, I'll be glad to write a note.
no, Your Honor, I don't want to go to jail.
Since I was really poor.
Oh, yeah, I forgot. Yep.
Seriously, if there's anything, what do you need, Ms. Gooden, as far as a note?
Your Honor, honestly, he doesn't believe I was here. I'll have him call.
Yeah, just tell him Judge Ketchel, he'll call me.